Good evening, good afternoon, and welcome to the September 25th regular meeting of the Eugene Planning Commission. We open the meeting with public comments. Even though it's not on our agenda, we still are going to do that anyways. If there's anybody who would like to comment, please fill out a green form. And I'm looking in the audience and I see none. Second item on the agenda is going to be legal training from staff. We are in the process of putting the PowerPoint in, but do you want to give us a preface as to what's going to happen first?
Sure. Thank you, Commissioner Borofsky. My name is Lauren Summers, and I am an assistant city attorney here at the City of Eugene. Planning staff asked me to come to this meeting and do a training for you today on public records, public meetings, and government ethics, which are, I would say, the three topics that really don't come up in the private sector, but are very important in the public sector. So if this is your first kind of go around in the public sector, you would have no reason to know about really any of these topics. Thank you. And even if it's not, it's always good to have a refresher. So I will kind of work my way through the PowerPoint. Please feel free to ask questions at any point. And I think what would be helpful to me to begin with is if we could, I'll go around, we don't need to introduce ourselves, but if you could give me a little bit of background on your involvement in the public sector, whether that's service on boards or commissions, if you're ever a public employee, whether in this state or another state, just to kind of give me an idea of how deep your background on some of these issues might be. So, Commissioner Borofsky, can I start with you?
Sure. So I've sat on several boards and commissions. I was on the City of Eugene's Budget Committee for about 7 years, so that was similar to this one, not quasi-judicial, but still public records and those types of things. Other boards and committees and those types of things that were a little less formal than a standing commission of the city. So that's kind of where I've been at.
Great.
And I served on the Springfield Planning Commission probably 30 years ago, as well as a couple of different committees in Springfield. Have been on the Eugene Planning Commission for I think 8 or 9 years now here, and just the various committees that are associated with this. But that's been kind of the extent of my involvement.
Great.
I'm similar to Commissioner Randall, with the exception of just my tenure. I'm in my first 4-year period, this is my 4th year on the Planning Commission, but I serve on other boards and commissions. This one being the more involved in terms of kind of that, the legal process in terms of quasi-judicial.
Great.
Good morning, Elliot Becker. I was assumed this position as Planning Commissioner July 1 of this year. Prior to that, no similar experience in Oregon. I've been here about 14 months. I did serve on Cable TV Commission in San Diego County in California. But I believe the rules would be different.
Awesome. So this is great. There's a variety of experience around the table. And for those of you who have served in the public sector in Oregon for a number of years, especially when it comes to the ethics portion of the presentation, you're probably aware that the ethics statutes have changed several times fairly recently. And so, things that used to be true are no longer true, and issues have changed a little bit. So especially when we come to ethics, if you feel like you have questions or if I'm saying things that are different from what you've heard in the past, please feel free to flag that for me and we can talk about it. Great. So, first topic is public records. And at bottom, both the public records and the public meetings laws are all about transparency. At some point, much like the federal government, the state of Oregon decided it's important for the public to understand what happens in government, how government entities make decisions, and to be able to kind of track that decision making through access to public records. And so I think for me, it's always helpful when I'm thinking about public records and public meetings, and sometimes we can get mired in the minutia of requirements, to remember that at bottom, it's really about transparency, that the public should have access to understanding how decisions are made, and should be able to have access to public documents. So the public records law generally requires that the public be given access to records and documents that are created, used, or retained by the city. And that is, very broadly what the public records law is about. So let's unpack that a little bit. What counts as a public record? Not everything is a public record, but most things are. Any record that contains information related to the conduct of the public's business, and that is owned, used, or retained by the city. So that could be things like agendas, the agenda for this meeting, emails that you send in your capacity as planning commissioners are public records. Maps, photographs, reports, kind of all the documents that you interact with in your capacity as planning commissioners probably are public records. And that is true whether they are in physical hard copy form or in digital form. So the next question that always comes up is, who has the right to inspect a public record? Does anyone? And the answer is generally yes. Every person, the law says, has the right to inspect public records as long as they're not exempt from disclosure. So there are some instances where something that would otherwise be a public record, the legislature has said you don't have to disclose this type of record for these particular reasons. But as long as the record itself is not exempt, basically anyone has the right to inspect it, and we don't really get to ask the reason that they want to look at it or who they are. If the city gets a public records request, as long as that record's not exempt, it goes to the person. The legislature has said the city has to respond to public records requests in a reasonable period of time, and the city has the ability to recoup the reasonable cost of responding to a public records request. So copy charges, some amount of money for staff time. The city has adopted a public records fee schedule to deal with all of that. And I'm telling you this not because you will ever be asked to respond directly to a public records request. You will not. Staff will take care of that. But just so you kind of understand the process. And you may be asked to provide records that are responsive. So for example, if somebody made a request for, all planning commission emails having to do with a particular application, staff might come to you and say, can you give me all your emails on that particular application? So one thing that I'll talk about a little bit more when it comes to retaining public records, one recommendation that I have for you and for all members of boards and commissions in the city is to think about creating either a separate email account, like a free Gmail account, or at least a separate folder in an existing email account where you keep all of your city-related emails. That way, if there is a public records request, you can say, well, anything I have would be in this place. And you don't have to go through all of your emails to try to pull out responsive emails. And no one else has to do that either. It's unlikely that this would happen, but it did in Beaverton many years ago when the city of Beaverton was trying to annex Nike into the city, and Nike did not want to be annexed. Nike made a request for a bunch of city council emails related to the Nike annexation. And the city councilors had, emails that were mixed in with their personal emails and used their personal email addresses. And at some point, someone had to go to their homes and go through their personal computers and email accounts and pull out the documents that were responsive to that request. And that's, that's not something that anybody really wants to have happen. So if you can say, truthfully, look, all of my City of Eugene email would be in this place. This is the only place that we need to look. That helps you, and it will help the city in the future if you ever need to produce documents in response to a public records request. So,
does that mean that I can't delete emails that have come from the city? So, I get 4 that say the agenda is here. and I've deleted some of those. Is that?
That's a great question, and I might look to staff for some of the answers to that. But yeah, so skipping ahead a little bit, we're talking about public disclosure requirements here. There are also public records retention requirements, because if we never had to keep any records, it wouldn't really help the public, right? Because they didn't exist. So yes, city email does have a retention period attached to it. Who is in charge of keeping that email is something that you'll need to work with staff on. So I assume that if it's an email that is coming from staff, the city is retaining it in some other way. And you would not also, if it's exactly the same email, need to retain a copy. But that's something that is worth having a discussion with staff about, you know, who's retaining these, who's in charge, what is the system that we have in place for that? And I don't know the answer to that.
Okay.
So we touched on this a little bit earlier. Are all public records available for inspection? No. Most are, but not all. There are certain types of public records that are exempt from disclosure, including, most important to me, attorney-client privilege communications. So if I write Planning Commission a letter that is meant to be attorney-client privileged, and someone requested that, that would not be disclosable because our attorney-client privilege communications are confidential. Records related to litigation, records related to personnel discipline, most of these exemptions will never apply to Planning Commission. Almost all of the records that you touch will be disclosable, are not exempt from disclosure. But this is just kind of for your information. If there's ever a question about whether a record is exempt from disclosure, staff will work with my office to determine whether or not that's the case, and then make a decision about disclosing the record. And then retention obligations, we kind of went through this already. The city is required to store public records for a particular period of time. That period of time depends on the type of record. So there are some records that the city is required to keep forever. There are some records that the city is required to keep only for a few months or not at all. It really depends on what we're talking about, both the type and the content of the record. There's a big old record retention schedule that the city recorder is very familiar with. But records that you create, emails, notes, things that you create in your capacity as a planning commissioner are public records and do need to be retained. And so then the question is one for staff to come up with a system for who's in charge of retaining what. Do you keep the emails that you send? Do you always copy a staff member so they keep it? Different departments and different boards and commissions have different systems. But bottom line, someone should be retaining them.
I guess my question would be then, I still have all of my AIS and notes from starting. So I have several file boxes of these now. And how long do I need to retain those? And then once my term on the commission expires, do I then still need to retain those, or is that what happens to those at that point?
That is a great...
My term will expire, I think, in another year and a half, or is it next summer? I forget which.
I think it's a life and a half.
A life and a half.
Yeah, no, that's a great question, and one that I cannot answer off the top of my head. I'm not familiar enough with the retention requirements, but that is something that staff and I could figure out an answer to.
And then another question, I think to one of the previous ones you had, let's say I have an email conversation on some of, like with Envision Eugene, there have been times where I've had an email conversation with either Terry or Alyssa related to, you know, some ideas or topics or whatever. Those, because it's my capacity, their staff, I do need to save those. And would those be subject to public records as well, even though it's not specific to, I guess, Envision Eugene is kind of a broad thing?
So yes, they would be public records. It's not limited to a specific development application. Anything that you do in your capacity as a planning commissioner.
Anything related to any email that I send to Robin or Alyssa or Terry or
Yep.
whomever would, okay.
Yep.
In your capacity as a planning.
In my
commissioner,
capacity as a
not
planning
in your
commissioner.
other capacities, yeah.
Okay.
Right.
But they're public
that's
record
true.
once
Well-
they hit my inbox or Robin's.
But as an architect with ideas that are relating to planning, I mean, I've been erring on the side of saving it because
Sure.
that just seems wise, but
Alyssa is correct. So we've a bunch of questions kind of get
Yeah.
commingled here, but the first question is the email a public record? Yes, I think generally it is if you are sending it in your capacity as planning commissioner. It is if Alyssa is receiving it in her capacity as a public employee, even if you are sending it in your private capacity as an architect.
kind of hard to separate that. I
Yeah.
mean, as far as an architect who happens to be on the planning commission.
It's difficult to tease out. Yeah. I would say you have some retention obligations regarding the emails that you send as a planning commissioner. You probably don't have retention obligations regarding the emails that you send as an architect, but Alyssa would because they are public records that need to be retained.
Well, I've been saving them, but I just was curious.
Yeah. Perfect. And, one other thing when we talk about emails, I'm sure you're well aware of this, but something that I like to remind myself of, the emails we send in our public capacities are public records and are almost certainly going to be disclosable. So thinking about when you're writing the email, is this something that I would mind seeing in the Register Guard? Because you may. And that it kind of helps me to think in that way too when I'm composing sometimes. We talked about creating a separate email address. Perfect. Okay. So then moving on to, that's it for me for today about public records. Does anyone have any final public records questions before we move on to public meetings? Seeing none. Okay, so public meetings, again, at bottom is a transparency law and requires that decisions made by governing bodies be made openly, that the public be able to understand why government bodies are making the decisions that they make. The public meetings law applies whenever a quorum of the, quote, governing body of a public body meets to discuss public business. So we need to unpack that a little bit too. The first thing we always look at is, do we have a quorum? And for planning commission purposes, that's 4. If you have something less than a quorum, then probably public meetings law does not apply, with a couple caveats that I'll get into in a minute. The second question is, what is the governing body of a public body? That's a statutory term. It has a specific legal meaning. Reading that, it would seem to me like it only means the city council. That is the governing body of the city of Eugene, but that's not the case. Governing body of a public body for purposes of public meetings law means the city council, it means boards and commissions, and it also means subcommittees of boards and commissions. So public meetings law applies to a quorum of the planning commission, but if the planning commission decided to create a subcommittee of 3 planning commissioners to work on a particular issue and report back to the whole planning commission, then a quorum of that subcommittee is also subject to the public meetings law. So if 2 of that subcommittee of 3 met, it would require notice and all of the things that go along with public meetings law. And then also discuss public business is kind of the third piece of that definition. So for example, if 4 planning commission members happen to be at a barbecue and talked about your families and how the ducks are doing and nothing to do with city business, that would not violate the public meetings law. There are a quorum of you, you are a governing body of a public body, but you're not talking about city business. I would say, if a quorum of you are ever in one place, red flags should go up about public meetings law, and you want to be real careful about not discussing public business outside of a public meeting. And then that last kind of line, think carefully about other instances where a quorum of the commission might discuss city business. The public meetings law and public records law, for that matter, were adopted a long time ago, prior to the rise of the internet. And the law doesn't really contemplate the other ways that we now are able to meet and have discussions electronically. So I would caution you to be careful about the types of electronic discussions that are now available to us. For example, if a quorum of the Planning Commission were all on Facebook at the same time commenting back and forth to each other about public business, I think that could be a violation of the public meetings law. Same with a quorum of the commission on Twitter, tweeting back and forth. I would say the closer in time a quorum of the commission is commenting on public business, the more it looks like a public meeting. And if it's a public meeting that the public doesn't have notice of or access to, that's a problem under the public meetings law. Email is tricky and a little bit more gray, but I still would caution against use of the reply all function in email among the commissioners. Because, you get 4 of you starting to email back and forth about public business and replying all, that starts to look more like a public meeting that the public doesn't have access to. It's fine to push information, but I would say save the discussion for a meeting. So I would discourage use of reply all. Commissioner Randall?
Question kind of back to the social media aspect. Scenario, the mayor posts on Facebook something about missing middle housing, let's say, and I comment, and then Commissioner Taylor comments, and then Commissioner Nicolello comments. Is that getting then, if 4 of us comment, are we in trouble?
I think that's getting close. Yeah, I would discourage that. So, if you...
That's good to know.
If Commissioner Randall comments and Commissioner Taylor is on and thinks, gosh, I'd really like to, but I see that 2 other planning commissioners have already commented, like, I'm going to not. And maybe I'll talk to Robin or Alyssa about scheduling a discussion for Planning Commission on that topic if I think that's worth a discussion.
Yeah, we're even talking about not even liking. So just.
Yeah, I guess comment and the like.
Really,
Yeah, any assent or dissent, I would think.
Yeah.
It's tricky.
Okay.
You're right.
I think, just be careful. And kind of come back to at bottom again, I would say, like, is this a discussion of public business that I think the public would want to be able to hear? If yes, then it really belongs in a public meeting, and let's save that for that time.
Lauren, I have a question. Yes. We've had situations, in fact, we have one coming up where there's a kickoff meeting for a neighborhood plan, and I think we want to broadly invite boards and commissioners to attend. Can a quorum attend?
A quorum can attend, but you
Okay.
should notice it as a public meeting.
Okay.
Yeah, so if, and that's true.
But not a planning commission meeting, just a public meeting.
Well, I mean, technically it would be a meeting of the Planning Commission. Yeah.
And if there was a
Yeah,
quorum of
see, it's-
Sustainability Commission, it's essentially a meeting of all of these boards. and commissions.
Yeah. Yeah. And that, that comes up sometimes too when you have, I don't think it happens so much in Eugene, but sometimes you'll have city councilors attend planning commission meetings, you'll have planning commissioners attend city council meetings. That can create an ex parte issue too, which we'll discuss later. But if you ever have a quorum of a board and commission in one place and the discussion is of city business, even if it's not a planning commission led discussion, if you're gathering information that could then be used in your official capacity, the safest thing is just to treat it as a public meeting, notice it. And
Even though it's not necessarily an agenda item yet,
right.
at some point it will be, probably. Okay.
Or, or let's go back to the definition.
And what if Alyssa doesn't know if she'll have a quorum of planning commissioners show up? I mean, it's one of those things, you invite a bunch of people and you may or may not have a quorum.
Yeah, well, I mean, that puts Alyssa in a little bit of a tough spot, so I think it's important to...
Face grimace over there. So it's going, how do I do this?
to, be as responsive as possible. I'm coming, I'm not coming, so that she knows we have a quorum, we don't have a quorum. Commissioner Brofsky.
So, getting back to city council meeting. If there's 4 of us in the audience of a city council meeting, city council is doing city business. So that would be a violation.
Well, it's already noticed as a city council meeting,
Right.
right? Presumably. But, I think if there's a quorum of you in one place and city business is being conducted, I would be thinking public meetings law.
Whether we're discussing the topic or not, if we're just in the audience,
Why don't you let me get back to you on that for sure? Because it seems like it is an important question to the commission, and I want to make sure I'm giving you the correct advice. So, if you don't mind,
Sure.
I'll table that, and I will get back to you before your next meeting.
Can I expand the question just for you to take? I don't expect an answer
Sure.
right now in context of what you just said. So, yeah, because that's an interesting situation. Let's say there's a planning commissioner that basically there's something about public safety, and there's four planning commissioners that happen to attend, but they're all attending on their own private business. So you've got also this other piece of us. How is that differentiated if we've got a quorum similar to the barbecue?
Sure.
But you're there in the capacity of a citizen and you have concerns. So I guess I would just follow
Yeah, that's a
through,
great
like,
question.
elaborate.
I will add that to my to my research. I appreciate the question, and I apologize for not being able to answer on the spot, but I will get you the answer. So we've been talking about public meetings law, and I just want to be clear about what the public meetings law requires. So the requirements of the public meetings law are intended to inform the public that a meeting is happening, let them know, what the topics of the meeting are, whether they would be interested in attending, and then give them the information to allow them to attend if they want. So meetings must be noticed. The law says at least 24 hours in advance. For your regular meetings, they're noticed well beyond that in advance. Unless it's an emergency, in which case you can provide less than 24 hours notice, but it really has to be a true emergency. It's not we forgot that we had this deadline coming up and we have to act before the deadline. It's the basement of City Hall is flooding and we need to get someone in to pump out the water, and we need the city council to meet to approve a contract. Meetings generally have to be held within the city of Eugene. I believe all of yours are. One exception would be, for example, I don't know this would ever happen, but if you wanted to have a joint meeting with the Planning Commission for Junction City, for example, you could meet in Junction City or in Eugene, whatever the home government of the other body is.
Springfield.
Yeah,
at
sure.
one point.
Perfect. That seems more likely. Meeting site has to be accessible to folks with mobility impairments. And then minutes of the meeting must be taken or the meeting must be recorded. I know Planning Commission meetings are audio and video recorded. That's great. That fulfills the public meetings law requirements. That in itself is not a requirement. Minutes are fine, but you need to do one or the other. And then public meetings law is a public access law, not necessarily a public participation law, So it says that the public has to be able to come to the meeting and watch and listen to you deliberate. It does not guarantee the public a chance to speak to you or interact with you. There are other laws that do, and some of them apply to planning commission. So, for example, public hearings are generally required when you're making quasi-judicial land use decisions. But the public meetings law itself is about the public's ability to see what happens, not necessarily to participate in what happens. And then there are some limited circumstances where boards and commissions can meet outside of the public view. I suspect that comes up rarely, if at all, for planning commission. but they're called executive sessions. It would allow Planning Commission, under certain very narrow circumstances, to meet in private, have private discussions, and then come back into a public session to make a final decision on whatever it is that you're discussing. The council uses executive sessions. I'm not sure if Planning Commission ever has. So this is more an informational item for you. But the reasons for executive session include to consider public records that are exempt from disclosure. So if you don't have to disclose the record, you shouldn't have to talk about it in front of people. To consult with the city attorney regarding litigation. Kind of a lot of the executive session bases mirror the public records exemptions. And just for your information, the law allows the news media to attend executive sessions, but not to report on what happens in the executive session. So it's sort of a check and balance for the board or commission to make sure that they're not straying beyond the basis for the executive session. But I said be aware of the parking lot conversation. So the member of the news media can't report on what was discussed in executive session, but if someone then walks up to you in the parking lot after and was like, that was crazy, what happened in executive session, and you start chatting with them about it, that conversation is not an executive session, and all of a sudden the door is open. So be careful, I would say. Yeah. It's unlikely that you'll ever go into executive session. If you do, staff will work with my office and will give you a much more in-depth tutorial if and when that ever happens. And then these are just, this is not legal advice, these are just tips that our office has kind of gathered over the years, and most of which I see this Planning Commission do a great job with. So the first is come prepared, read the materials before you come to the meeting. I know that you get a lot of materials, but it certainly makes the meeting move more smoothly if folks are familiar with what we're talking about. Be respectful of other commissioners and the public. I've never seen anything other than respectful behavior by the Planning Commission, but I will say that when I used to represent other governments, that sometimes was a problem. And it was a problem sometimes that folks were too informal. So I used to represent a lot of very small governments, including lots of rural fire districts. And their meetings were very informal. Everyone called each other by their first names. There were, they took comments from the audience at any time. And it seemed fine because everyone knew everyone and it was fine. Until it wasn't fine, until there was a hot button issue in the community, and all of a sudden, tempers flared, and there was a lot of difficulty controlling what happened at meetings. And so I think there is a lot of value in being a little bit more formal, both with each other and with the public, and making sure that everyone understands any limits on public participation well in advance, so it doesn't feel like someone is being silenced because you don't like what they're saying. This is just the way we always do it. It's always only 3 minutes for public comment or whatever it is. And then that last bullet point, it can be helpful for chair and vice chair to meet with planning staff in advance of a meeting. I know that happens sometimes, to go over agenda items and talk about what might come up. And that's fine because that's less than a quorum of the Planning Commission, so it's not subject to the public meetings law. All right, that's it for public meetings. Any other questions? I have my homework. Okay, moving on to government ethics. So, government ethics in Oregon, a couple of things that I want to highlight for you. Ethics questions tend to be extremely fact-specific. So there's no way in one presentation for me to kind of give you the answers to any ethics question that might come up. My hope is that in this presentation, you'll get enough information so that if you get in a situation that might create an ethics issue, a red flag will go up and you'll think, I should call Robin, I should call Alyssa. They can maybe talk to Lauren for me and we'll, get this figured out. So the ethics statutes have some particular definitions that I'll quickly go through. we talk a lot about public officials when we talk about government ethics, and that means anyone serving the city as an elected official, an appointed official, so that's boards and commission members, an employee, and even a volunteer. So all of those people, if they're acting in their capacity as a public employee, are, well, and even sometimes when they're not, are public officials for purposes of the ethics statutes. So you are a public official. You'll hear relative a lot. Relative means something specific for the ethics statutes. It's not everyone that we would count as a relative in the in the real world. It means specifically spouses, parents, kids, individuals for whom you have a legal support obligation, individuals for whom you provide some sort of benefit, so health insurance maybe. But it does not mean aunts, uncles, cousins, grandparents, boyfriends, girlfriends. So when we talk about relative for purposes of the ethics statutes, it's a specific group of people and not necessarily everyone that you would consider a relative otherwise. And then member of household means anyone who lives with you. Business and business with which you are associated will come up as well. Business is basically what you would think of a business, an entity operated for gain, but it doesn't mean government bodies, and it doesn't mean 501c nonprofits. And then business with which you are associated, it depends on the type of business. So if it's private, if you are an employee or a director or an owner, if it's a publicly held corporation, you have to own a lot of stock or interest in it before it becomes a business with which you're associated. So if you own, $500 in Nike stock, Nike is not a business with which you're associated. You have to own more than $100,000 worth of stock. And then for public officials who are required to file a statement of economic interest, which is planning commissioners, any business that produces 10 or more % of your annual household income is a business with which you're associated, if it doesn't otherwise fall into one of those other categories. So just to kind of, if you have an ethics question that comes up, we will run through this analysis again. This is just kind of a quick overview for you. And as far as statements of economic interest, those are an annual obligation. It usually happens in April-ish, about the same time you file your taxes. The Ethics Commission will send them out, and I don't know if they come to staff and are forwarded on, or
I can't remember how.
you'll get them. We'll make sure that you get them.
Question.
Yeah.
Just kind of scenario. I also serve as on the board of directors of a 501c3 and am an officer. I'm the secretary of the board.
Okay.
So as far as the statement, it's volunteer, but do I still need to, I've been reporting that, I think, on my SEI form anyway.
It probably doesn't hurt to over-report, but
Okay.
I would say,
But I don't derive a salary from that.
yep,
Volunteer, but
if it's a 501c tax exempt nonprofit where you only are associated in a non-remunerative capacity, so you're not getting paid, then it's not a business,
okay.
and it's not a business with which you're associated. So
That board then hires me as an architect to do architectural services, then I'm in.
then it may be,
Then-
yeah. Okay. So I'm going to give you kind of 3 big rules to think about when we're thinking about Oregon government ethics law. The first rule is don't use your office for gain. And that's pretty much what it sounds like. Don't use or attempt to use your official position, so your position as a planning commissioner, to obtain a financial gain or avoid a financial detriment, so to get something that's worth something or to avoid paying money, if that opportunity would not be available to you but for the fact that you are a planning commissioner. So, for example, you go to a restaurant in town, I'm sure this happens all the time, and they say, gosh, thank you for your service on the Planning Commission. We really appreciate you. I want to give you this dinner for free tonight because you are a planning commissioner. That's when your red flag should go up and think, am I only getting this free dinner because I am a planning commissioner? It sure sounds like it. That would be a violation of the use of office for gain provision. And that is true even when it doesn't cost the city anything. So there was a famous example many years ago now where somebody high up, maybe even the director of SAFE, the State Accident Insurance Fund, he was buying fleet vehicles for the agency. And he thought, gosh, these are pretty nice, and I'm in the market for a new car. And I'm getting a good deal because I'm buying, a large number of them. I get the fleet discount. And so he did the right thing. He actually called his attorney and said, hey, is it okay if I tack another car onto the order? I'll pay for it. It won't cost SAFE any money. But, I like these cars. It's a good deal. Is that okay? And the attorney said, yeah, I think that's okay. Somebody thought it wasn't okay. An ethics complaint was filed, went all the way up to the Oregon Supreme Court. And they said, yeah, that's a violation of this provision because you wouldn't have access to that deal except for the fact that you are the director of SAFE. It didn't cost the public any money, it didn't cost the agency any money, but you're only getting this good deal because you are the director of SAFE. You couldn't walk down to your neighborhood car dealer and get that same deal. So that's a problem. There are some exceptions from the rule, things like official compensation, reimbursement of expenses. Those technically are only available to you because you're a planning commissioner, but it's okay to get reimbursed for, mileage or something if you travel.
Is it okay to put that you serve on the planning commission on your resume that you hand out to potential clients?
That's a good question.
Because I do. If I shouldn't be, I better take it off.
Yeah, that's.
It's among a lot of other.
Sure.
It's relative experiences, that would be on the
it
resume.
seems like it should be okay, and that's why I'd put it on there, but.
I can certainly think about that more. It's not an immediate
to your list.
financial gain or avoidance of financial
I
detriment.
need to
But
change my resume.
I think it's probably okay, but I will let you know.
Well, that other attorney thought it was probably okay to buy that car.
That's
too.
true. That's true. We're not always right, contrary to popular belief. There was also some controversy for a while about cell phone plans that city employees could get a discount when they went to Verizon to sign up for a cell phone plan. And is that a violation of this rule because they're getting it because they're a city employee? And the Ethics Commission actually did some research and found out that no, it wasn't because they were a city employee, it was because they were an employee of a large corporation. Those same discounts were available to Dell and Hewlett-Packard and. So the Ethics Commission said, in that case, it was fine because it's not really a use of office, it's the fact that you are an employee of a large employer. So rule number 1, don't use your office for gain. Rule number 2, gifts. Gifts are generally limited to $50 per year per giver. And the specific rule is public officials, and this applies to your relatives and members of your households as well, may generally not accept gifts worth more than $50 in a calendar year from, and this is the important part, a source with a legislative or administrative interest in the decisions that you make as a planning commissioner. Legislative or administrative interest means an interest that is financial and that is distinct from that of the general public. So for example, an architectural firm in town offers you a gift, they probably do have a legislative or administrative interest in the decisions that you make as a planning commissioner. There's a solid chance that they will be in front of you at some point in your capacity as a planning commissioner. So you should be thinking about, all right, so how much is this gift worth? How many gifts, if any, have I accepted from this source in the past calendar year? If it takes me over the $50 limit, maybe, I should probably not take it. On the other hand, if someone who has no financial interest in the decisions that you make as a planning commissioner offers you a gift, then these gift limits don't apply. Planning Commission is a little tricky. Your decisions probably affect, or potentially affect, more people than some of the other boards and commission members on the city. So this is something that you probably do need to be thinking about a little bit more than some other public officials. For me, I don't make a lot of decisions that have a financial impact on folks in the community, so I can just rake in the gifts. But you guys might. So, when someone offers you a gift, you should be kind of running this scenario through your head. Each individual has a separate $50 per year gift limit, so that's exciting. And each source has a separate $50 per year gift limit. I know some public officials who have said, it's too hard, I don't want to have to worry about doing these calculations all the time, I'm just not going to accept any gifts. And that is a legitimate decision for you to make. It's not required. The law does allow you to accept some gifts within certain limits, but that also does require you to kind of remember and think about who the giver is and how many gifts you've accepted and all of those things. So.
Does that include, say, going out for lunch or coffee or
it
any of
does.
those things?
Yeah. Thank you for the tee up. So that has come up quite a bit in the discussion of gifts, because it seems like, say I have a friend, we've been friends forever, that friend has a legislative or administrative interest in the decisions that I'm making. We have a standing lunch date every month, and we just trade off. I pay one month, they pay the next month. Over the year, it probably evens out. Seems like that should be fine, but technically, over the year, if that person gives you more than $50 worth of lunches, even if you're also giving them more than $50 worth of lunches, that would be a violation of the gift rule.
I'm just relating back to the previous commission experience I had. And I don't know if it comes up here or how it's decided, but let's say there's a huge project and the developer wants to invite us to a presentation, has a fairly lavish meal or something like that. It's a question.
Yeah.
Is a decision made on behalf of the entire commission? Do we all have to go? And how does that tie into this ethics rules?
That's a great question. So it seems to me like in your scenario, the developer would have a legislative or a financial interest in the decision that the Planning Commission would or might make on the developer's application. So gift limits would definitely apply. I think also, if it's a quasi-judicial land use application, which we'll get into a little bit more at the end of the presentation, you might have ex parte contact issues if the developer is inviting you for lunch and to talk to you about what the development might look like in the application. So I think there are potentially several issues with the scenario that you posited, both ethics and quasi-judicial land use decision related.
Would that be something that we possibly would contact you or your department on?
Yeah, I think,
because we may not be able to quantify the value.
Mm-hmm. I think you would start with staff, so Robin or Alyssa, but they probably would contact my department, and we would then kind of go through the analysis that we just went through, and I would probably have a lot of questions about, who is sponsoring this lunch? What does it really cost? What are the other legal issues that might come up around that?
Thank you.
Two other questions. One is the gift. I'm just thinking, what is it? So if you're an employee, so I'll just give my example. Work for an architecture firm, I'm an employee.
Mm-hmm.
We get Christmas gifts at the end of the year.
Mm-hmm.
I don't actually control those gifts. They're not really for the office.
Good question. Yeah.
So how is that impacting, how is that impacting me? I need to go to the owners and say, you need to stop accepting gifts because I'm an employee and I'm on this board.
Right. Great questions. So we've got a couple of.
I just do not eat the chocolate.
Yeah.
I mean, I could just not eat.
You could-
Which I don't.
you could not.
Because I have dietary, thank you. I have dietary restrictions. So
Perfect.
okay.
But that is a great segue into, so there are some exceptions from the gift limits. And I've listed them. These are not all of the exceptions. These are the ones that I think might be most pertinent to Planning Commission, except for campaign contributions. You don't need this. But so they include things like gifts from your relatives and members of your household. Even if that person has a financial interest in the decisions that you make as a planning commissioner, you can accept a Christmas gift from your mother. And the final one, Commissioner Taylor, I think gets closer to your question. There is an exception for gifts with economic value that are given as a usual or customary practice of your private business or position as a volunteer that bear no relationship to your position as a public official. So I think the example that you gave hits this one on the nose. I usually say, and I will say here, use caution when relying on this exemption. But it is set up for exactly kind of what you're talking about, where there are these traditional
End of year Christmas break.
gifts, things that your private employer does that really don't have any bearing on your capacity as a planning commissioner. That exception came up because lots of legislators are doctors. Doctors get drug samples. And the pharmaceutical companies definitely have a financial interest in what the Oregon legislature does. And the doctors are like, wait a minute, does this mean I can't get free drug samples? So the legislature, thinking thoughtfully of itself, created this exception, but it helps us as well.
I'm just going to do a time check here. We're almost at an hour in.
Oh, thank you. We're getting,
And we do have another fairly important agenda item. So just,
I will speed. So Rule 1, don't use your office for gain. Rule 2, gifts. Rule 3, conflicts of interest. A conflict of interest will arise when a public official takes an action or makes a decision or recommendation that either could or will create a financial benefit or detriment for you, your relative, or a business with which you are associated. An actual conflict means the financial benefit or loss will happen. A potential conflict means it could happen, we're not sure. We have our own conflict of interest provisions in the code that are similar to, but not exactly the same as state law requirements. And I've highlighted the pieces in red that are a little bit different. It's important for you to know that they're there, but probably if something will create a conflict of interest for you under state law, it would be a problem under the code as well, or if it would be a problem under the code, it would also be a problem under state law. So if you think you might have a conflict of interest, that's when you talk to Alyssa, talk to Robin, they'll coordinate with me and we will help you walk through it if necessary. And so I'll just go through this really quickly. If you have an actual conflict, so financial benefit or loss will happen, I'm sorry, actually in the case of both, the first thing that you have to do is declare the conflict. You have to do it on the record in a meeting, and you have to do it in enough detail so that folks can understand what the conflict is. It can't just be, I have a conflict, I'm not going to participate. It has to be, I have a conflict because my architecture firm represents the applicant in this matter, and so I'm going to recuse myself. If it's only a potential conflict, once you have declared it, that's all you have to do. You can still participate in the discussion and the decision on the matter. You just have to let folks know that the potential for a conflict is there. If it's an actual conflict, you still have to declare, but then you cannot participate, you cannot discuss, you are done as far as that is concerned.
And on the potential conflict, though, once we declare it, isn't it usually opened up that if somebody has a problem with that or challenges our ability to make an unbiased decision, they can do that?
Yeah, so bias is a little bit different but related, and the Eugene Code does allow for some, challenges. You're correct. There are a few exemptions from conflicts of interest if the conflict affects a huge class of people in the same way it affects you. So, for example, the city council is passing a new tax that would create a financial benefit or detriment for the councilors, but also everyone else in the city. They can still talk about it and vote on it because the class exemption applies. It has to be a really big class. If it's a class of 10 or 25, I would be concerned about that. If it's the whole city, I would not be. If the conflict arises from your membership in or service on the board of a nonprofit, and I'm not sure how that would work. Well, so say the nonprofit that you serve on the board of has an application in front of the Planning Commission. Technically, it's not a conflict of interest for you because it's a nonprofit. And then if the conflict arises from membership in a particular business or industry that is required by law as a prerequisite to your service on the board or commission, you get a pass. That's not going to be true for you in Planning Commission. An example might be if the State Insurance Commission required that a couple people from the insurance industry be on the commission, they would have some conflicts that would come up, obviously, but they get a pass under this exemption. We don't have a similar requirement for planning commissioners. I'm going to skip through, in the interest of time, how other city staff deal with conflicts of interest, because it's just informational for you. You should know that the city has its own ethics code. It's in Chapter 2. It mirrors the state ethics provisions, but if you ever want to look it up, that's where it is. And then quickly, I wanted to talk to you just a little bit about legislative versus quasi-judicial and what you're expected to do in those different situations. So Planning Commission can be asked to act in a legislative capacity and can be asked to act in a quasi-judicial capacity. You act in your legislative capacity when you are making a recommendation on Type 5 applications. So when a code amendment comes in front of you, a refinement plan amendment comes in front of you, those are legislative decisions. And you are not there aren't as many kind of rules and restrictions on what Planning Commission can look at or talk about when you are acting in a legislative capacity. It's okay for you to be biased. But when you're acting in a quasi-judicial capacity, you're acting like a judge in a judge-like capacity. And so the parties in front of you are entitled to an unbiased decision maker. So it's important to understand which capacity you are acting in when you are being asked to make a recommendation or a decision on something. Generally, when it's a code amendment, it's legislative. When it's a Type 2 or Type 3 application, it's quasi-judicial. And if you ever have a question about that, staff can easily answer that for you. So when we're talking about the quasi-judicial capacity, you're acting like a judge. It's important. The parties are entitled to an impartial, unbiased decision maker. And that means that you need to be able to declare that you can make decisions without bias and based on the materials in the record. It doesn't necessarily mean that you don't have feelings about the application or that you don't have feelings about the type of application generally. But when it comes to the particular application in front of you, you can put those feelings aside, you can concentrate on what's in the record, and you can make a decision based on the land use code criteria and the materials in the record. And if you ever feel like you can't do that, that's important to know as well. And you'll probably need to recuse yourself. And then the other thing that comes up in terms of quasi-judicial decisions are ex parte contacts. So that's a legal term that generally means information that comes to you that's not included in the record of the decision in front of you. And that could be a conversation that you have with a neighbor. It could be something you read in the newspaper. It could be, if you decided to go out and do a personal site visit. All of those things are discouraged because they constitute ex parte contacts. And that means that you have access to information that the other parties might not. So if it will come up from time to time. And if you run into an ex parte contact, what you need to do is declare that it happened. Say, last Saturday I was at the grocery store and a neighbor came up to me and wanted to talk about this particular application, and I told them I couldn't, but they kept talking at me for a couple of minutes and expressed their concerns about this issue to do with the application. I still feel like I can make an unbiased decision. And then the other parties will have a chance to respond to that communication if they want to.
I have a question on this.
Yeah.
So, and it's a two-part question. So the first part is, how far back does that go? So a lot of us here sit on neighborhood boards. Sometimes there's discussion at neighborhood boards about land use decisions coming up in the neighborhood. Not that has come before a hearings official, not that has been appealed to us or to another appeal body. So I know I've sat in on several neighborhood meetings of that type. So would that be, I declare if it does come before us, that would be, I'd say I was in meetings 2 years ago and this was discussed?
I think it probably doesn't hurt. I would say my advice is always to try to limit those contacts where possible. So if you, I mean, obviously if something has been appealed or you know it's coming to you, I would stop participating in things where ex parte contacts are possible. If, you know, in the case of some applications, it's early and it's not clear that it will come to Planning Commission, but it's a hotly contested application and it seems likely that it will be appealed, I would limit my contacts then as well.
Okay, and the second question being is, once an application has been put in and deemed complete and goes before a hearings official, would it be, I could attend the hearing because everything that's going to be said at the hearing would be part of the record. Is that correct?
It would be part of the record, that is correct. Yeah, you probably could.
I mean, at that point, everything is part of the record.
Right.
So I wouldn't say that that's ex parte because it's part of the record, correct?
I mean, you could certainly belt and suspenders it and say, I was at the hearing.
Okay.
But that's available to everyone else. And
Okay, thank you.
Commissioner Taylor.
Another question. You know, I've been really conservative over my tenure, so I don't read the paper at all. I mean, that's one example. But I know that there have been times, and I'm bringing this up because I'm wondering, what if by, if we included it in the public record? I know there was a quasi-judicial process recently that essentially the paper articles were actually included. So if that was a regular practice, then there wouldn't necessarily be a problem. You could all say, read the paper. But I'm just curious, things like that are really, it's more of it's very public. You happen to sit in front. I don't at all, but I know at that time I was aware that there were other planning commissioners that actually do open the paper.
Oh, sure.
You know, I mean, there's a lot of other things in the paper, like sales, or a house, or a cat, or a dog. Yeah.
Yes. So if a newspaper article is also included in the record, then that's fine.
Yeah.
If it's not, then technically it is information that's outside of the record that you have that other planning commissioners might not have or the parties might not have. And so...
just request for it to be part of the record then.
Or, you know, a disclosure that I read this article on this day.
Okay.
All right, that's it for me. And I know we're a little over time. Any other questions?
If you think of questions that you don't have it off the top of your head right now, feel free to get them to staff and they'll try and answer them, and then it'll be part of a public records search in years to come.
Maybe.
Thank you for the presentation.
Yeah, thank you for having me.
Very much.
Yeah, thank you.
All right, our next item is going to be on transportation system development charges, and Dan is going to lead the discussion, but it looks like we have other staff in the room as well.
Thank you.
You're welcome. This affects a large class of people.
Interesting presentation, thank you.
share the keyboard if necessary.
And again, I would give a preface just that we are running a little bit behind in time, so if we can push through the presentation as quickly as we can, because I'm sure there's going to be people who would like to have discussion, and I'd love to be able to.
You want to hold our questions till the end?
We'll see how it goes. Yeah.
Okay. Well, good afternoon. I'm Dan Kaler with Public Works Engineering. And I'll start out with this, a brief background of the effort thus far, and then I'll basically have Julia and Deb contribute more on the TSP and the methodology component, and then Eric will also follow up on some of the incentives that we're looking at for the methodology for our transportation system development charges. So as a brief background, the statewide initiative was basically implemented in 1991, and the city of Eugene is basically following the requirement in Chapter 223 of the revised statute, and it basically identifies the procedures, the appeal processes, and the necessary timelines to implement system development charges. There has been a variety of amendments since 1991. In particular, there's a requirement that we have a plan list, basically that we identify those projects which are intended to serve growth. We basically document those as part of an adopted plan list, and then basically the costs associated with those project plans kind of go into the formulation of the methodology for the actual SDC charge. There are basically 5 type of infrastructure components that are eligible for system development charges, transportation just being one of them. And I guess the key requirement, or I guess the flexibility of the adoption of the methodology is that you can certainly go below whatever is deemed to be the maximum allowable charge. So it gives the community flexibility if they want to alter or certainly improve, I guess, or hasten some of the development. They could lower the actual system development charge. From a local perspective, I think one of the key policy decisions looked at, or just, I guess, prevented the public from subsidizing growth. So the intent was this policy would guide the payment of those fees that are serving growth to be the responsibility of development, but also the decision that there also be the capability to subsidize, maybe in the instance of like low-income exemptions, or offer incentives to help guide some of the growth, whether it be for compact type of housing developments or more of the environmental friendly, where we're trying to minimize the vehicle travel and reduce the carbon emissions. Thus far, we've had a variety of outreach meetings. Over the last 16 months, we've met with the Active Transportation Group twice now, the Chamber of Commerce once, Leadership Council twice, Home Builders last month, and today we're meeting with you. I can say that some of the common questions thus far have been clarification on what is an eligible project. Questions have been of the order of, is a local improvement, such as like infill of sidewalk infrastructure, is that an eligible improvement? And in this case, since it's not serving capacity, the impacts of growth, it wouldn't be. So we're looking at cases or maybe like a multi-use path where it's accommodating growth is really the key distinguisher. Other questions have been just dealing with what are other communities establishing as their system development charges. So we had a variety of examples of similar population, what they're charging, so particularly give people a feel for where we currently stand and where we're proposing to be so far as our financial impact. Other questions dealt with incentives. How do we want to, or is the capability to promote certain activities or certain type of development activity, as well as the capability of having more affordable housing. I think from the home builders' perspective, they're opting for more of a lower impact fee to encourage affordability for their future construction projects. And then, so far as the timeline for the implementation, shortly after we had a mature project list that we derived from the transportation system plan, we formalized our project list, at least had a tentative version of the project list. And from that, we developed a fee schedule using, basically, there's 2 proposed methodologies. And our next step would be, after conducting these outreach events, is present those to City Council in November. Tentatively, we're looking at mid-November, and then approximately 90 days from that, we would have a public hearing. And I guess the key requirements there is we need to have a 90-day notification prior to the hearing, and also have the methodology available 60 days for public review. And optimistically, I think we're looking at potentially then a March 2018 implementation date for the methodology. So with that, I'll let Deb give a brief overview of the methodology.
Okay. Thanks, Dan. As Dan mentioned, the SDCs, or TSDCs for transportation SDCs, are an important funding mechanism for projects in the TSP. Specifically, we're talking about the multimodal projects within 20 years, improvements to both existing roadways to add multimodal improvements, intersection improvements, as well as off-street bike and pedestrian facilities. As any sort of specialty area of work, we have our terms, which are very clear to us, but may be very confusing to others who don't work in this area. So I will try to clarify some of those. And generally, these come out of the statutes. So as Dan mentioned, we have statutes in Oregon that govern SDCs, and so some of these terms of reference come right out of that. When we talk about capacity, we're talking about costs or projects that either build new facilities or enhance the level of performance of existing facilities. So improvements to intersections and things that make reduce congestion and improve the level of service. Improvement fees are forward-looking. They are based on they recover costs associated with future improvements, whereas reimbursement fees, as suggests, are to reimburse the city for past investments where there's available capacity to service the needs of growth. Another term that relates to one of the options, methodological options, is the existing system value, and this is basically the estimated cost to replace the entire transportation system that you have in place today. So I'll use some of these terms as we go through. As has been mentioned, SDCs are specific to new development, generally charged at the time a building permit is requested. They are charged based on impact, and so the city reviews the type of development, the nature of the development, the size, to identify what that impact would be, and then calculate the fee. So for apartment buildings, for example, impact is generally trips. So how many trips is your development going to generate? And so for apartments, we know from industry data that each apartment dwelling unit generates about 5.58 trips in the PM peak hour. And therefore, if there's 100 apartments in that complex, the rate would be based on the trip rate times the number of units times that cost per trip. And there's a schedule for all the various different development types and their estimated impact. The basic SDC equation is pretty simple. It's costs divided by trips gives you a cost per trip. sounds simple. Of course, the devil's in the details, and the details that get particularly complex in this situation are how do we determine those TSDC eligible costs? What does it mean that when we talk about a capacity cost, and what does it mean when we're differentiating a cost for growth versus a cost for existing development? So under both of the options that were discussed in your briefing paper, we have to figure out which portion of the project list that comes out of the TSP are for capacity. As I said, either new facilities or enhancing the level of performance of existing facilities. So that means we don't count replacement capacity cost or street preservation kind of costs. Those are more maintenance related costs. So we're looking, city staff and the consulting team reviewed each project to determine what was a capacity cost versus a replacement capacity cost. Then we take out other funding, because if there's other funding, either from an external source like ODOT that's going to pay for a project, then the city doesn't need to include that as part of the systems development charges. Grants, another example, particularly on some of the active mode type projects. And so what's left then is the new capacity costs that the SDCs can recover. So the second part, so we talked about capacity costs. The second part is how do we determine what's a growth cost? There's two methods that were described in the material that was provided. What I'm going to say about this method, it's not important that you understand each one of those boxes, is that it's a complicated approach. It looks at each mode differently. So if it's an improvement on a road, we look at the volumes on the road and how many of those future trips do we think is going to be generated by growth versus what's existing development. Julia, who worked on the TSP, goes into the model and pulls out all of that data. It's a very technical, physical measure of capacity, and will, in most cases, result in a project being allocated less than 100% to new development, because there's probably, unless it's a new roadway in a new area, it's going to probably have existing traffic on it. So it's going to be prorated. Same with the active modes. We look at the miles per capita that we're planning in the future, and based on the population increase, then we can make an apportionment between existing and future development. So that's, and it supports both an improvement fee as well as a reimbursement fee calculation. Option 2, instead of looking at physical capacity measures, we're basically looking at a financial measure. That, remember, the SDC statutes, one of the main things up front says we're looking about an equitable means of funding future capacity. So one basis to do that is to say, what's the value of the system per trip today for existing trips? And growth is going to pay for the next increment up to that same level of investment per trip. So we've calculated the existing system value to be close to $6,400 per existing trip, based on the complete inventory of facilities, roadways, bike ped, bridges, all of that. Divide that by the number of current trips. That's kind of the ceiling, and then any capacity investment up to that is needed to continue to build out the system for each new trip that comes in. When we look at the project list that comes out of the TSP and we look at those capacity costs identified for the planned improvements, divide that over the growth trips, so you get your forward-looking cost per trip, and that's $5,100, which is less than the existing system value per trip. So under that method, 100% of the new capacity costs can be attributed to providing a level of service for new development up to that level. So it's just a very different way of viewing how we determine what is growth share, equitable share, and both methods are used currently to develop SDCs in Oregon. So just a summary of the two options. Obviously, I think, option 2 being this historical value per trip is going to generate a higher fee because, as I mentioned, 100% of the new capacity costs may be attributable to growth, so the fee is about $5,100. Under option 1, when we go through all of those, look at each project and look at the trips and allocate it on its basis, generates a fee of about $3,000 for a single family dwelling unit. And this is before any discounts, which Eric will talk about. So obviously more funds available to fund the project list, but the flip side is it's a higher cost for development, and in these types of discussions we always need to balance both considerations. It's more the option 1 with having the reimbursement component does provide some additional flexibility in that reimbursement fees can be used for any type of transportation system capital improvement, even for rehabilitation of existing facilities, because that's recovering costs that have already been paid for. So the city can put that to use as it chooses. In terms of stakeholder acceptance, I think, as Dan said, you've gotten some feedback already. The option 1 with the reimbursement improvement has been historically a more common approach. It's more consistent with what the city's existing methodology is based on. So there's some familiarity with it, and it does have a lower fee. Option 2, higher fee, fairly new method being applied. So there may be some resistance there. That's all I had on the options. I'm going to turn it over to Eric unless you want to have any questions for this piece.
Do you guys want to do questions on this part, or do you want to wait till the end?
Up to you.
Let's finish the presentation.
Sure. So we have direction from the 2012 Envision Eugene recommendation to look at different ways that we can incentivize development that reflects our community vision. And so system development charges are one of the ways that we can do that by altering them to support or incentivize development that meets these the pillars which you guys are exceedingly familiar with. But just to highlight a couple of the pillars that we feel this incentive program would support, providing housing affordable to all income levels. If we can incentivize smaller homes, transit-oriented development, that makes housing more affordable for folks, and then promote compact urban development and efficient transportation options. So we're aligning these incentives with our key corridors and our frequent transit network and downtown in order to support compact development and efficient transportation. So we got started on this by asking ourselves a few questions. Could adjustments to SDCs be used to incentivize development that helps implement our community vision? What models exist in Eugene and elsewhere for this kind of incentive program? And how likely is a reduction in SDCs to move the needle on compact development? And we approach this in a few ways. So reviewing model programs from other communities and in Eugene. So Eugene already has a few incentive programs through SDCs. There's the Affordable Housing Incentive, Green Building Incentive, and a Nodal Development Incentive, all of which reduce SDCs for developments that meet certain criteria. And then we also looked at incentive programs outside of Eugene. Bellingham, Portland, and Springfield all have SDC reduction or waiver programs that we looked at. The incentive program that we're proposing for compact development along our key corridors and downtown mimics the Bellingham program that's been in existence for a few years. And then the SDU incentive that we're proposing mimics the Portland and Springfield examples, although it's notable that it doesn't go quite as far as Portland and Springfield, where they offer a 100% reduction of all system development charges. We're only proposing a 50% reduction for the transportation SDC at this point. There was also, over the course of the years, the City of Eugene has produced some of its own analysis around SDCs and whether or not reducing SDCs would make a difference in the market, and how implementable it would be to have a SDC incentive program for compact growth. So we looked at that analysis. And we also talked to developers to find out whether this was going to be a meaningful incentive that would, as I said, move the needle on the type of growth that we want to see in our community. And what we learned from those interviews is that SDCs make up about 10% of total project costs. And while it wouldn't sort of overwhelmingly make these projects immediately financeable or implementable, it is a meaningful market signal, and it directs development towards the areas that we want to see development happen. So it's not going to make a huge change, but it would be a minor incentive and a step in the right direction.
And Eric, one thing I might point out is just in the Portland area, one thing that comes up a lot is when people are going through their performas for a new development, and there's several instances in the Portland Code as well as Washington County Code where there's the potential for a reduced SDC, but the criteria is a little bit nebulous. And I think one thing to point out here is we're establishing some pretty specific criteria, so people have more certainty when they're looking at their finances related to, we can actually rely on these because it's black and white criteria rather than gray criteria. And I think that's an important topic to note as we're looking at these incentives.
Thanks. Yeah. One thing I also would note here is just that the 10% of project cost, that refers to the entire SDC, like the bucket of charges. Right now we're only talking about the transportation. Our intention is to work with parks going forward to look at the parks SDC and wastewater further down the line. So, but right now for today's discussion we're only talking about transportation. So as I mentioned, we're proposing two incentives. The first would be a 50% reduction in the transportation SDC for SDUs across Eugene. So this is not location specific. It's all secondary dwelling units, and it would be, as I said, a 50% reduction. The second incentive that we are proposing, I've thrown up our community vision here just to show you how the location of the incentives align with our key corridors, downtown, and our frequent transit network. So this is really similar to the Bellingham example that we relied on. So we have three areas where developments would qualify for an incentive with varying percentage reductions for each criteria, and they're designed to provide the most incentive to developments that most implement our vision. So we have 30% for downtown, 15% for key corridors, and 10% for development within nodes. The 10% for nodes is already on the books. It's already a policy incentive that we have. So that's the location, and developments would only receive an incentive under one of those criteria. And then if you move down to transit proximity, we're proposing a 10% reduction for developments within a quarter mile of the frequent transit network, and a 5% reduction for development within a half mile And then we are also proposing a 10% reduction for developments that have a signed TDM agreement with the city. So developments can receive incentives under all three of the buckets, but only one incentive under each bucket. And their total incentive will not exceed 50%. So if a development is downtown, it would get 30%. It would all of downtown is within a quarter-mile buffer, so they get an additional 10%. So that brings them up to 40. And if they decide to sign a TDM agreement with the city, they could get another 10%, bringing them up to the maximum of 50. But if that development was along a key corridor, they would only get 15%. Then they might get 10% and 10%, resulting in 35%. So it's a little complicated, but staff, Lorena is here. We've been working closely with Lorena to make sure that this can be implemented and administrated without too many snafus. And that's my last slide. Oh, unless
The last slide is more for follow-up. If you have questions, you certainly can. If we don't discuss them as part of this meeting, you can follow up later through an email to a general email box for SDC.
Okay. I have several people in the queue. Krista Taylor is first.
So Commissioner Borowski, I have several questions, so maybe if we want to have a couple rounds, so I'll keep it to
Do a couple now.
Okay. So one, I just want some clarification because we have the public listening, is just to make sure I'm understanding. So essentially ORS 223, it really defines an overall methodology for the state. Is that correct? So your option 1 and option 2, in terms of transparency about where that technical methodology comes from, is fairly consistent throughout the state.
It provides general guidelines, a framework. It doesn't get down to the specifics of what type of level of service or standard do you need to use. So there is flexibility. Both options have been tested and are allowable under the statutes.
But what it does do, Deb, I think it clarifies what you can and cannot do. Okay. So it gives you those bookends.
Exactly.
So there's options within those bookends, but you know where you fall within those. If you fall outside there, it's not available under Oregon state law.
Okay. And then some of the data that you're getting, are you using them from adopted plans, like economic opportunity report, or various relevant plans? So you're not this is an arbitrary collection of data. You've got manuals, trip manual. You've got various manuals that are either adopted citywide or state or federal.
So there's a couple of key sources of data that we use. One is when it relates to trying to assess what a new development impact might be and what the applicable fee is. We rely on a national database produced by the Institute of Transportation Engineers called Trip Generation, and it's a manual that's used throughout the nation. It's used in Eugene on quasi-judicial processes. It's used pretty much by every jurisdiction that I know of, because it actually has hundreds of thousands of studies that say, on average, here's what this type of use in this type of context generates on a vehicular trip basis. The other piece that we rely on is, as part of the transportation system planning, we work with LCOG, and we talked about this, I think, when I was in front of you guys for the TSP, LCOG, to figure out, okay, here's what the Eugene comprehensive plan, here's what the Springfield comprehensive plan would suggest in terms of what happens between now and what kind of growth happens between now and 2035, and how does that equate to the number of people that are going to ride their bike in the future, that are going to take transit. So those are our two primary sources of data in terms of looking at trip making within the SDCs. And that is consistent with pretty much how everybody that I'm aware of does their SDCs as well.
Perfect. So one other question, and then I'll wait till the next round, is if you can explain, because I think there's somewhat some confusion, I know you've done this in the past, is when an individual developer pays SDCs, the question is, why isn't my road in front of my development being improved? So where the SDCs are allocated, how those decisions are made, so that there's better understanding of the public of how that's prioritized. And even though your block of where your development is might not see those improvements for your particular project. Or will they?
Yeah. Well, yeah, it's really dependent upon the project, adopted project plan list. Some of those projects are upon development type projects. I mean, whenever a development activity occurs, then that particular, whether it be a collector or Archilla Street, could be improved to accommodate that growth. But it's dependent upon the project plan list.
So you're going back to the TSP rather than the priority of this person's money is not directly allocated to their.
Exactly.
Right.
These are system-wide fees. Yes.
That being said, though, what's important, and we often encourage our private clients to do this, is if you're adjacent to an SDC project, you have SDCs, there's provisions within the SDC for you to get credit for making those improvements. So if you go ahead and make those improvements on behalf of fulfilling your conditions of approval, you get credit against your SDC. So then you actually see the benefit of that SDC fee that you're being assessed immediately, rather than knowing that when you go downtown and there's SDC money being used on said project, the whole system benefits, including you. But it's a tangible fee, you can feel it versus something else.
Mr. Randall.
And I have two questions. The first one, Eric, you were mentioning that Portland and Springfield had 100% credits for SDUs, and we only did 50. Can you explain how we got there and why we didn't also do 100?
Yeah, I mean, we have, I think we wanted to take sort of an incremental step towards incentivizing SDUs. Since this has been out in the public and we've been chatting with folks, it does sound like there is support out there for a more aggressive incentive. And certainly if the elected officials, if council, mayor and council want to head in that direction, or if we get direction to head down that road, we would support it. I mean, we would do that work to make that happen.
Thanks. Then my second question gets to the criteria where you were saying only one applies from each section. Mm-hmm. Are those, if let's say I'm doing an SDU downtown, is my maximum still 50, or would it be 50 plus the 30% of location?
It's a good question. I think the zoning so we are using the downtown plan boundary for.
So it's actually within the actual downtown.
Yeah. So the zoning, we'd have to look at the zoning to see whether there's anywhere where an SDU would be possible within the downtown plan.
Or you could put transit proximity on that, because that would go out a little farther from just the downtown. Or is all of this criteria only downtown?
All of the criteria, maybe I'll just
in that chart.
So all of that criteria is applicable across the city.
Because this would also apply to the transit corridors that we've talked about.
That's right.
Okay.
Yeah. So if there was a development along a key corridor, if somebody along a key.
So if I did an SDU along a key transit corridor, what would my SDC credits be? Would they be cumulative, or would it cap out at the 50% under
It's
the
cumulative.
It is cumulative. Okay.
I think we'd have to look at the zoning to see whether there's anywhere where that would apply. Though.
Okay.
It'd be approved development, yeah. But
I think we're relying on the zoning to implement our vision, and this is aligns with that vision. So. The zoning should preclude developments that don't meet that vision.
So just a point of clarification on Portland related to SDUs. So used to, SDUs could just be done without any type of SDC even thought about. And so the intent of the council, and Deb, correct me if I'm wrong, is that we recognize that we've been letting the SDUs kind of go under the radar. We're going to start implementing fees on them, but we're going to phase in the approach. So rather than shocking people right away saying, oh, well, we realize that you're doing SDUs and we really should be assessing you. We're going to phase in a discount so that you won't pay them in the beginning, but I think in 2019,
Yeah.
the provision
Technically, it
sunsets.
sunsets, yeah.
And so whether the council
carried over.
decides to renew that waiver or they actually start implementing the fees will be determined in 2019.
Yeah.
I'm not sure I completely understand that. Are you saying that
It has a sunset clause on the 100% waiver, and then it goes, technically, that only goes through the end of fiscal year 2019, and then the 50% charge kicks back in. But they may carry it over.
and
We
this
don't
is
know.
just on transportation?
That's, for Portland, it's on all.
Well, and I guess that was my follow-up
Yeah.
question on that. But what we're talking about here, that is just transportation.
Yeah, we've taken the opportunity to work alongside Dan as he's redoing this methodology, and we've already started conversations with parks as well. So the intention is to move through all of the transportation or all of the SDCs as they're being reworked.
Commissioner Jaworski.
Yeah, I have several questions. I'll ask two at this time. The first one has two parts. It's actually simple. You, on page 3 of your handout today, you mentioned the final plan list, part A and B to that first question. Where can I find this plan list? And second, does April mean you made it, or is April when it was adopted, or will it wait till February when the council adopts everything?
Well, I can go to page 3. You know, it initially was synced with the proposal for TSP, so I think we initiated our plan list based upon kind of the mature status. We kind of waited till the TSP was further along, but in April, I think, you said slide 3?
Third, it's 5.
Well, it's page 3 on the...
Okay, yeah, I got you. Okay, yeah.
Yeah, I'm sorry.
Yep.
But I just
Okay.
want to know where I can find that.
Yeah.
Was it adopted, or is it going to be adopted in February?
Yeah, well, it's part of the actually adoption process, I think.
It's,
Yes, Julia's working on the plan.
Yeah.
Chapter 5 of the TSP. So,
Is the list? Is that what you're saying?
so
Chapter-
it lists out each of the individual projects, and the projects that are considered part of this in Chapter 5 are in tables 5.1 and then 5.3 and I'm sorry, I didn't print out the pages and pages of pedestrian bicycle, but the tables with the pedestrian bicycle. So what's not in there is the projects that are study projects. Those are not within the SDC projects. The projects that are potential projects for the beyond 20-year time frame that are in Chapter 5 are not included as well.
And, yeah,
Okay, so I was more confused than I thought. I thought the final plan list was something you developed that's only a few years long, and that reflects why you charge the costs. So your costs are determined on a 20-year plan.
correct.
Thank you. That was my first question. Second question, again, on this handout, page 4 and 7, you have two references. On page 4, you talk about the availability of these funds for new streets. And then again, on page 11, when you talk about, excuse me, page 7, when you talk about, when you talk about implications of options, you go flexibility, the reimbursement fee may be spent on any capital cost. And then right below that, you say this is consistent with the current approach. So when I listen to both of those, I get the understanding that SDCs can be used on any kind of street, yet I was led to believe they can only be used on arterial and collectors.
So there are two components to the SDC under option 1. The reimbursement, the improvement fee can only be spent in accordance with the project list. And we will have a separate project list that the city adopts that has mostly all the projects out of the TSP. But those are arterial and collector streets, so the improvement fees can only be spent on those projects. But the reimbursement fee, which is the smaller component under option 1, it can be spent on any transportation capital improvement project. So
That's the
Yeah.
first time I've heard that. That's
Yeah.
not new, that's always.
That's not new.
Okay.
Yeah, and it's in the law. Yeah, the state law.
But just a clarification, but our city council has adopted a separate resolution years ago that directed us to focus that reimbursement fee on pavement preservation projects. And that's where we spent all that money.
So it's not being used on any street, because that resolution is still in effect then?
Right.
So what that says is really not, it should have said what the council resolution is then, if we're going to be briefed on this. Okay, thank you.
All right, I have myself in the queue, and I've got it in second rounds. So for me, this process is balls in the air, because there's several different, in my view, there's several different policies that are being implicated by this. There's policies that deal with how we fund our transportation system. There's policies that deal with how we fund our multimodal transportation system. There's policies on how we deal with affordable housing. And then there's also the funding balance. So for me, there should have been somebody from finance here, because there's several things that are in the air right now as far as transportation financing. And one of those is the bond measure in November. So I hope that the work session isn't scheduled before the vote of the bond measure. It definitely needs to happen after that. Second thing is we have a new transportation funding bill from the state that came through. That is also one of the balls that we're juggling here that we know how to deal with. The third is the limitations on those fundings. So a lot of those fundings are curb to curb. The reimbursement part is really one of our key areas for multimodal funding, other than what is being put aside in the bond measure, right? I see head shakes.
So, yeah, the project list includes off-street bike pedestrian facilities.
So it doesn't
So,
have to be
yeah.
reimbursed. As long as
Correct.
it's
Absolutely.
well,
Yeah. Yeah.
Capacity improvement. Okay.
And one other point I just want to make related to the transportation package, because we were all hoping that we would get an influx of money for the Beltline, which didn't happen. But the Beltline highway that is in Chapter 5 in our list of projects and the bridge is not part of the costs that are in the SDC fee. So that is a point, so that we don't have overlap between ODOT funding or state funding versus SDC funding.
So my second, so those are the balls that I'm seeing, because I sit on too many committees and I see these balls flying in front of me in different places. Getting to your table for criteria for reductions, I'm concerned about the term residential, especially upon corridors, because to me that doesn't necessarily get us to densification along the corridors. If you've got a 15,000 square foot lot along a corridor and put one house on it, and you get a reduction on transportation SDCs, to me that doesn't go to what our goals are about densifications on the corridor. So I think that by having residential in there, we should have some sort of a tie to densification along those corridors. You know, that it's at the upper limit of the density requirements for that zoning, or something to that effect. Because to say that I've got a big parcel along River Road and I want to build a really nice house on there, and that is going to densification along our urban cores, that's not doing it. It's just giving them a reduction because they are within a specific plan boundary. So I think that that's something that I would hope would get looked at. And then the other thing I'm concerned about is the key corridors, or the bus, rapid transit, and
Frequent transit network.
the frequent transit network, and that being anyone that is proposed. So we've got 5 corridors proposed. Even at the best case scenario, maybe 3 of those will be completed within the 20-year horizon. So to say that we're doing STC reimbursements on something that's not going to be built for maybe 50 years seems problematic to me.
Commissioner, I actually raised that same question amongst our group for contemplation, because do you build it with the anticipation that they will come, or do you build it because they're actually served by transit now? And there are 2 things I think that are important to highlight. Is one, we are looking at a 20-year plan, and within the TSP we worked with LTD, and I'm sorry for all my use of acronyms, but I know you guys are familiar with those, to identify what we could rely upon as our future transit network, given where we know about the funding scenarios. The other element that I've been kind of wrestling with in my mind is, okay, should we really be incenting for something that might not happen for 18 years? And the way that I've kind of resolved, at least for my own brain, is to think about, well, if you do have an area, a corridor where you see a major influx of densification happening, that's going to have LTD in the region take a second look at the funding priorities. And so they actually might kind of work together. So it's a chicken and egg thing. It's definitely complicated, and it's a bit more risky to think about the potential corridors, but there is some interplay there, I think, to at least recognize.
Thank you. I'll move on. Commissioner Taylor is in
no questions, thank you.
Commissioner Taylor, second round.
Ed, I just have a couple more questions. One, can you please explain, I think you kind of did, but I'm just going to reiterate, make sure I understand. So in terms of the criteria for incentives, you said the total incentives, the total number in the buckets can't exceed 50% for all the buckets. I just want to clearly understand, so you've got green building also, for instance. So is that all buckets, all STC, or all buckets just within transportation?
Just within, so somebody could have a green building and get 10%, and then they could also apply for an incentive with this.
And so they could reach their 50% max here,
yeah,
and still get 10% in green building. So they can go over 50% in terms of the comprehensive.
Yeah, it's just within this incentive program they can't get over 50%.
Great. Okay. The other question I have is, this is more of an encouraging thing. I think I would encourage you to look at the 7 pillars. Because of the fact that we are looking at comprehensive transportation elements within our community, I look at protect, repair, and enhance neighborhood livability. So looking more closely, because there's some, I think the 2 you've identified are really obvious, but I don't know, just in terms of alignment with the pillars, I think it might be broader than just those 2. But that was just my initial thought.
Yeah, I did have a line in here that I didn't mention to spit it out, that definitely, if you think about it, all of these pillars are...
Yeah, exactly.
You can make an argument that all of them apply.
Great. And if that's helpful in terms of public transparency, because it really is. It's not really limited to 2. Yeah.
And the whole notion of the TSP is we put together policies and projects to support the vision of the pillars and of the comprehensive plan. So it's not the other way around. It's not the TSP's, quote, driving it. The TSP is there to support the land use vision.
Commissioner Randall?
Under the state framework slide that you had, you said the methodology established a maximum allowable SDC charge. And so what we're doing with this is taking, I'm assuming we're maybe at the maximum by default, I don't know, but then we're taking the incentives to reduce that. Does state law limit us then to not going beyond, let's say we're incentivizing in a transit corridor and we want to make up those funds from a different area, maybe that's farther out, less walkable, less bikeable, less transit, we can't exceed that maximum regardless.
That's correct.
Okay, so you can't recoup it from a different area.
We fondly refer to that as good trips and bad trips.
Yeah.
So I think people, the trick is trying to incentivize people to not develop on the fringe when you really want intensification.
Okay.
And you can't penalize
people,
but you can charge them, not give them any discounts for developing on the fringe, because it costs more to create infrastructure out to the fringe areas, because the notion is you don't have that.
Are we at the maximum otherwise?
There's not a maximum dollar amount.
Well, the fees under the two options, those are the maximums under that methodology. So you've got two different methodologies that generate two different numbers. Whichever one you adopt as your methodology, that will establish the maximum.
Okay.
But the state rules don't say thou shalt not charge more than $6,000
Yeah, it's
per
very
single
community
family.
specific.
Yeah.
Commissioner Jaworski.
Yeah, I also had some questions on the criteria issue. I know it mentions 30% if you're downtown. I see a lot of buildings being torn down then, because I don't see a lot of vacant land downtown that you're going to have all this new densification occurring. That's just a comment. So I don't understand why, if you're going along either key corridors and nodal development areas, it's only 15 and 10. It would seem to me that that's an opportunity where there is vacant land and redevelopment, which I see all the time occurring outside of the downtown core. They're not getting the same incentive. So that's the first question. Why did you put so much weight on downtown versus these other areas where I actually see it being developed?
So there's definitely the brownfield versus greenfield, where there's ability to redevelop with a higher and better use in accordance with the zoning, or just undeveloped properties. But the issue really goes to how people travel and the type of facilities that they have to travel and to do things other than drive in their own car. And so in the downtown, when we look at how do people get around downtown versus how do people get around out on in Santa Clara, yes, there's some transit, but there's much more reliance on single occupancy vehicle travel as a whole than there is in the downtown. So the incentive program is set up to more mirror how people actually, the modes they actually use to travel in those different areas.
I would say that also in our consultation through Envision Eugene, we've heard that there's a lot of consensus around having our highest densities downtown.
No, I understand that, but it's hard being on a planning commission and not plan. I heard the other discussion is, what do you do first? Do you build it? Do they come? And the issue is, if you're planning, you got to think that they are going to come. And number one, all along transit corridors, there should be a minimum zoning of either 5 or 8 height if you really want density, not allowing them to build along these transit corridors one-level things. And second, there should be incentives to encourage that, because if you really build up along those corridors, the transit will come and you'll have less use of the car, because it'll otherwise be so jammed you can't move anyway, since we went to a new level that we can go to E or whatever. So I'm really confused with this, because I don't see this as looking at the 20-year plan and saying this is where we want to be. I see that this is easy, let's do it here. So that's just a comment.
We are at 1:30. I have a quick comment myself. Christian Taylor had one more question. Is it okay with the body to continue on for another 5 minutes?
I have a meeting, but 5 works.
I do too. Yes.
Okay.
Sir.
Then with that, my question is a quick one. You propose the incentives for the downtown area. I can't tell if the eWeb property is
It's
in there.
It's included.
It is included.
Yeah.
That's what I wanted
We didn't
to.
include we have another map that zooms in on downtown, and it shows the downtown plan boundary, which includes the eWeb property.
Okay, good. That's what I wanted to know. Commissioner Taylor.
So mine's a little bit broader, and I'm not sure you need to address it. What did you want from the Planning Commission today? I guess that is my main question, because we obviously didn't talk about option 1 or option 2 and what our thoughts are around it. Sure. So, yeah.
At this point, just general feedback, concerns on either option, and more particular, just direction on the incentives, particularly to direct development activity that conforms with planning goals.
So option 1 and option 2, obviously you're actually going to continue the outreach process. Or are you done? I mean,
Yeah, this was kind of the final stop on our outreach
okay.
of local committees.
And when you go to city council, are you going to approach it a similar way in terms of option 1 or option 2, or do you have a preference?
Well,
Are you going to change your approach in
I can probably defer to Mark on that, but
I think we've got to figure out what we've heard from the different outreach groups and then the pros and cons of each of those options. Just a point of clarification, even though they come up with different dollar amounts, it's not a requirement that you charge the maximum. Springfield, for example, their council didn't feel comfortable with charging the maximum, so they just, you can by policy charge less than the maximum. So it's, if it's just a matter of the dollar amount, that can be adjusted. And the council policy is to charge growth the full freight, but it's not required under the statute.
And many cities exercise that. They decided it's just politically they can't have an SDC that's completely out of whack with the rest of the region, and so they artificially reduce the full amount.
And one last item is, so we're not a part of this decision-making process, but can we be copied on, like just beforehand in terms of what that evaluation is? Like you said, once you evaluate the public process, the outreach process, what that evaluation.
yeah, on that last slide, there was for the interested parties. They'll give you advance notice of when the final methodology is available for public review.
Great. Perfect.
Yeah.
Thank you. We're interested parties.
Okay, thank you for the presentation.
Thank you.
A quick thing, anything from staff, Robin, that we should be aware of?
Given the time now, I'll pass.
Okay, and then I think we'll do the same thing with items from commission, unless there's anything that's burning that needs to be put out there. Okay, with that, we're adjourned.
Thank you. Great presentation. Thank you.
Thank you.